Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about cross-examining analysts in drug cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Denis Turgeon was charged with a number of offenses related to methamphetamine. As part of his trial, he applied to cross-examine the analyst who analyzed the substances that he was found with that were later determined to be methamphetamine. And in the course of this application, he sought disclosure of pages of material related to the analysis of the substance. He was disclosed approximately 2,000 pages of material. So the comparator that was used to show that the substances were in fact methamphetamine may have not been the correct comparator. It was on this basis that he brought his application to cross-examine the analyst. The court denied the application. He appealed his conviction. The appeal was unsuccessful, and he sought leave to the Supreme Court of Canada, specifically on the issue of what should the standard be to cross-examine an analyst in a drug case. Now, Mr. Turgeon's case raises really important issues, because the Court of Appeal and the trial judge had both determined that his application was effectively being brought on speculative grounds, that two of the pages referring to a standard that may not have been the correct standard was merely a fishing expedition, and that he didn't have a sufficient evidentiary basis to bring the analyst to court. The Court of Appeal had determined that the reason for these provisions are to prevent analysts from unnecessarily wasting their time being subjected to lengthy cross-examination about matters that were not controversial. But there was controversy in his case. And what more could Mr. Turgeon actually do? These were important questions for the Supreme Court of Canada. Where there's generally a prohibition on disclosure of this information without making an O'Connor application to get the records disclosed to you, and then subsequently a prohibition on cross-examine the analyst, there's really no ability for an applicant to actually lay a foundation to bring the analyst to court for cross-examination on the analysis that was done if the material can't be obtained in the first place, and cross-examination would reveal the very problems. This is effectively the catch-22 that's set up in the legislation, and there is no good mechanism to reconcile this. The Supreme Court of Canada had the opportunity to make situations where people want to cross-examine the people who are saying these were drugs, when you're saying I'm innocent and they weren't drugs, compellable to court and subject to cross-examination. But unfortunately, the Supreme Court of Canada has still allowed the difficulty to continue. Ultimately, this is going to result in wrongful convictions of individuals whose analyses were not done correctly. The Supreme Court of Canada should revisit this issue, and hopefully in another case they will take the opportunity to redefine the test for when an analyst should be compelled to court, to make it less onerous and to change it from what it effectively is now, which is impossible to meet. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.